Hi everyone, my name is Laura. I'm not going to have any slides with me today, but I hope and trust that my presentation will be easy enough to follow. So let's get into it. So my talk is titled Welcomeness as a Mediator in Data Protection Legislation, a Feminist Alternative to Consent. So I would like to start this presentation by sharing a common scenario. The city administration of one's town has finally gone digital, and many services that were previously done through paper correspondence are now fully online. One goes to the website, excited about the opportunity to simplify one's life, only to find out that before one can proceed to using this platform, one must consent to the collection and usage of personal data. What this actually means, few users can tell, but we all have to consent to it, lest we don't get our mandatory city registration done in 2 weeks if you live in Germany. In the act of consenting, we supposedly use our agency to exercise a normative power, that of allowing for something to be done to us that without our consent would be considered a transgression. But in this well-known routine scenario, has anyone actually exercised their agency in the way that we expect free citizens would do that? I don't think so. Furthermore, I think that we have the same problem with consent in another well-known routine scenario, sexual relations. In this talk, I will apply a feminist critique of consent in sexual relations, mainly Catherine McKinnon's, to the institution of consent in data protection practices in the European Union. I will argue that consent as a standard for legitimizing data processing obscures the fact that consent giving is itself shaped by the general power imbalance between the data subject and the data controller, much in the way in which it happens in sexual relations. So the linguistic and conceptual overlap is there. Consent as an institution has been for a long time at the center of the feminist exploration of normative powers in a particular context, that of sexual and gender relations, and as it happens, it is also a central concept to the normative interactions that happen around data in the digital realm. So starting from this conceptual coincidence, I would like to offer some insights about the nature of data, the data subject, data relations, and the normative characteristics of consent in the context of power imbalances around information. These insights will be distributed along the lines of two main theses. So the first is that the socio-ontological transformation of private digital users into data subjects by virtue of the sustained participation in data collection agreements is an operation that replicates the creation of gendered subjects through sexual relations. And the second is that the relationship of extraction between digital service providers, in which the users are seen as inexhaustible sites of data to be mined for accumulation of economic capital, mirrors dynamics of sexual objectification and exploitation. Using these two theses as a takeoff point, I will offer an alternative model to consent as a mediator for privacy-centered interactions in EU data protection legislation. Welcomeness, that's the name of the alternative. This model is based on Catherine McKinnon's exploration of welcomeness as a framework to express agential power and autonomy in sexual relations. According to McKinnon, welcomeness is the main feature of interactions that are actually desired or wanted, which are characterized by a marked enthusiasm about the mutuality present in these interactions. Ultimately, I hope to offer a glimpse of what data protection looks like when the standard for determining personal agency is welcomeness as opposed to consent, and the radical implications this has for effectively exercising agency in the age of big data. But let's start from the beginning. The general scenario in which meaningful and necessary social interactions take place has become increasingly digital, although I'm not saying that this is a new trend, because I locate the explosion of the digital in the 3 decades between the 1980s and the 2010s. The digitalization of spaces of discourse and social realization has materialized in 3 observable ways. So the first is the ubiquitous collection and computation of data. The second is the shift towards big data and predictive analysis. And the third is the implementation of automated evaluation and decision-making procedures. I would like to highlight 2 facets of the concept of data for this analysis. So on the one hand, data as computized information collected from an individual's interactions with their environment and then data as a legally relevant concept. I introduced this split because it is only through the latter, so data as a legally relevant concept, that data becomes part of a larger framework of privacy, or at least privacy as relevant for legal theory. The attachment of data to privacy is my point of departure for a feminist analysis of consent in data protection, because as we know, privacy is one of those core sites where feminist jurisprudence has spent a lot of time and a lot of energy. So a bit of the legal framework of data handling in the EU and the role of consent in it. There are two major regulative statutes that create the overarching framework of data processing and data privacy. On the one hand, the General Data Protection Regulation, or GDPR, and on the other hand, the Data Act of 2023. It is a question to what extent legal mechanisms that aim to ensure the protection of privacy broadly understood, so for example, European Convention of Human Rights and the like, are part of this overarching framework, but I will not address this question right now. So I will not include human rights mechanisms in my analysis. So the GDPR establishes 6 legal bases for the collection and processing of personal data through digital media. Out of these, only 1 is directly consent-based. The other 5 allow for the processing of data through a different justification. So while it is true that consent is by far not the only, and it could even be argued that it's not the one through which most data operations online are allowed, I want to insist on the centrality of consent for data operations because of the perception of it data subjects have. Think of the scenario I presented at the beginning of this talk. In that case, aside from the fact that the terms of personal data processing are beyond obscure for most people, it is a reasonable assumption most people make that the terms they have been made to agree to, as it concerns the collection and processing of their personal data, encompasses the entirety of this activity. It is so much. You would think that this is it. Partly because of the fact that the data activities to which they apparently consent are so daunting in their scope, users of digital services rightfully believe that that's all they have to agree to, and that if they don't consent in part or to the totality of it, they are effectively controlling and restricting access to what can be known about their experiences in the world. So even if consent was or is a residual basis for data collection and processing in the EU, it is the one that users directly interact with in a face-fronting manner that suggests to them control over their data and their experiences in the world, and for this reason is especially relevant. So now that I have given a bit of background about the role of consent in data privacy regulatory mechanisms in the EU, I would like to get into the 2 theses that I mentioned earlier. Both come from a place that rejects a categorical division between privacy as conceptualized in feminist studies for the purposes of modeling gender and sexual relations, and privacy in digital interactions. Furthermore, both are rooted in the premise that digital service providers and users stand in a structural relationship of inequality, mainly expressed in asymmetrical access to information about the parties and the uses of the collected data. In this sense, my critique of consent as a mediator in data processing relations belongs to the strand of feminist jurisprudence that has focused on consent as a way of theorizing choice and agency in the context of social determinants of power, and the way the latter constitutes social subjects. From feminist jurisprudence exploration of consent, 2 main takeaways can be drawn that are generally agreed upon. The first is that as a proxy or model for personal agency, consent is insufficient. The second is that a consent-based model of social interactions usually conceals structural situations of injustice between the parties that the normative power of consent cannot remedy. So the first thesis was the socio-ontological transformation of private digital users into data subjects. So this first proposition says that, contrary to what data privacy mechanisms assume, there is no such a thing as a data subject, but rather a data subject is created in the context of information technologies and the data industry behind them. Of course, this formulation mirrors Simone de Beauvoir's very famous theory about the constitution of women as a gender subject through a relentless process of sexual objectification that little has to do with the actual nature of human beings. I propose that an equivalent process of objectification takes place in the context of data relations, and it is through this process that the data subject is created. In order for this argument to succeed, the characteristics of a data subject need to be made visible. In the law of the European Union, the data subject is the natural person to whom relate any personal data being processed. So it's very circular, right? And then personal data is defined as any information relating to an identified or identifiable natural person or data subject. So the data subject is therefore brought to life through the definition of personal data, and its existence in law will depend on whether a processing of data is recognized as processing of personal data. It already got tricky, it gets a little bit trickier, because the devil is in the qualitative characteristics of personal data and the fact that this is not self-explanatory. Data doesn't just exist. It is not just a fact of life that a person is male, female, non-binary, or trans, so with data points. It is also not a fact of life that a person is German, Latin American, Finnish, or whatever. Data, as characterized before, is the result of the deliberate and conscious processing of information about the phenomenological experience of personhood of any given subject within the available possibilities given by a particular set of codes and institutions of knowledge that, to be sure, much precede and exceed practices of data collection. I could summarize this point in the following way. The processing of information through the existing codes of knowledge produces data about people whose lives are actually not confined to the definition of those data points, but by the existence of these data points, a feedback loop is created that reduces people to the way their lives fit in the data. Thus, objectification takes place. So the second proposition says that the exploitative relation between data controllers and data subjects mirrors dynamics of sexual exploitation. What this means is that the creation of data subjects through the process of objectification outlined just before has had as one of its consequences the exploitation of data subjects in a way that resonates with the way subjects objectified through gender are seen and used as sites of endless capitalization. There is no denying that the data economy is one of the big economic sides of the current times, and one need only to look at the role of data processing and transacting of leading economic powerhouses such as Google or Meta to understand just how vital it has become for companies to mine data subjects for all they've got and work towards making their models for analyzing reality as accurate as they can sell them. The problem is, of course, that if reality doesn't fit their models, it is not the models that are changed. Rather, through product marketing and algorithmic intervention in sites of public discourse, like social media, it is reality itself that is made to change to make information and data fit together so it can be sold and processed accurately. Think of Catherine McKinnon's theorizing about the exploitation behind pornography, which was one of her main sites of interest. Since it is not true that women as humans are the sexual objects who enjoy all kinds of sexual exploits being done to them day in and day out, the way pornography portrays it, the pornographic industry has it as one of its central aims to turn women into that subject, since otherwise its business model would be unsustainable. So it is that reality changes to accommodate and facilitate the exploitation of gendered and data subjects. Which leads me to my main point of critique, which is that consent as an institution is an inadequate remedy for this situation. In her political critique of consent, McKinnon points out that in the life of inequality, much routine, sad resignation, or worse, passes for voluntariness. The latter, so voluntariness, is expressed through consent. Furthermore, consent covers multitudinous forms of structural hegemony that are typically so elided as not to be seen to infect or inflect, far less vitiate, a person's freedom. I propose that this sentiment, first formulated to capture the dynamics of sexual relations, mirrors the structural features of data relations. This is so for a number of reasons. First, the enormous inequality in the access to information between data controllers and data subjects. It is not just that data controllers know a lot more about the lives of data subjects than the other way around, but also that data subjects know next to nothing about what happens to their information once it has been transformed into data. This should already be enough to vitiate consent in the way that we understand the conditions of consent to be successful. But some other reasons are that the notion of consent fails to account for power structures which shape the situation in which consent can be and is expected to be given. It also presupposes a free, liberal, and individualistic subject capable of making meaningful decisions in the face of immense disparities in the access to information, as well as in the face of material constraints that heavily influence the kind of decisions available to them. As such, consent cannot be expected to deliver on the promise of it as a normative mechanism, that it will remedy the power imbalances in a relation or interaction that would otherwise be exploitative or unjust. It's just not enough. So what is the alternative? Perhaps it's welcomeness as an alternative to consent. So what do liberal principles of equality require of privacy laws? I think that they certainly require more than a half-hearted acceptance to be a participant in data processes that are beyond the understanding of most digital users. When McKinnon says about consent-based models that the presence of consent does not make an interaction equal, it makes it tolerated, or it makes it the less bad of the alternatives, or the concept of consent is an inherently unequal one, simultaneously silently presupposing that the parties to it are equals whether they are not. She's getting at the insurmountable problem of freedom of choice in conditions of structural inequality, present in the interactions by social design. Nonetheless, there are in her scholarship also models to express agential power and autonomy, albeit always under conditions of equality between the participants. One such alternative is to focus on the notion of welcomeness. Welcomeness, again, is the main feature of interactions that are actually desired or wanted. In these situations, the desire to participate in them is never described in terms of having consented to it, but rather in a marked enthusiasm about the mutuality and openness to these interactions. This is a model that requires equality between the participants, which can be acquired when a hierarchical dominant consciously redresses their superior power instead of using that power to coerce. In this way, they ensure the agency of the other participant and ensure that it is not compromised, and as such the interaction becomes morally permissible. This moral permissibility renders consent useless, since there are no prohibitive negative rights in the first place that are thought possible to be waived off by the action of giving consent. The point is that it's not the same thing to acquiesce to having something done to one than to enthusiastically participate in something. It's not only a difference in how one enters an interaction, rather it speaks to two different kinds of interactions altogether. The situation to which one acquiesces or consents is one in which a normative power is needed to allow something that would otherwise be a harm. Instead, one enthusiastically participates in something in which harm is not in the horizon. So out of these options, which one is the one that consent is trying to mediate, according to the GDPR and the Data Act? If we follow McKinnon in the understanding that consent only makes sense in the first scenario, the exploitative scenario, then one can see that legal mechanisms of data privacy recognize the existence of a deep inequality between data controllers and data subjects. At which point, the question is, why is this general environment of data interactions allowed? I mean, capitalism, but one could say that the consent-based model that EU law operates under to mediate access to digital privacy in its basic assumption and their logical ordering promotes an inherently unequal notion of digital personhood. I would like to briefly point out that in her works, McKinnon uses the concept of the violation of women and that of the intrusion on those with less power interchangeably, and thus allows for an analysis such as a gender theory of data inequality to exist. just to close, I want to say that it is by far not true that data protection law is as good as it can get, because it is not true that interactions between subjects and digital platforms who collect data is as good as it can be. In this sense, any regulatory applications of McKinnon's theory of consent and welcomeness shall be one that addresses the baseline conditions of digital life, from the kinds of products that are sold and created to the way these are designed, to ensure that a situation of disproportionate inequalities doesn't arise, and therefore creates negative rights claims that are subsequently addressed through consent. The way forward would require for platforms and other data controllers to perform conscious actions to redress their disproportionate power in a way that enables and uninhibits the agency of digital users. I would suggest that on the one hand, this would undo most of the digital products people are sold or forced to use, at least in the way that we know them now. In an economy in which data, or the right to surveil users, is used as counter-performance for access to most digital services, undoing the exploitation of data subjects would constitute its shot of grace. Another more moderate option would be for data controllers to be responsive to the dispositions, wishes, and preferences of digital users, their actual wishes, not the less bad option offered by the platform. This might require digital platforms to design their products under a completely different model, one that doesn't ask users, what can we do to you for our sake, will you let me? And it would also require regulatory mechanisms of digital privacy that don't allow otherwise. Thank you.